Okay, welcome all of you to this today's seminar. We're very happy to have with us Dr. Amnéus and Professor Gregor Noll to discuss with us together the UN Security Council Resolution 1973, a week old. Or 8 days old today. We are going to structure the seminar as follows. I'll introduce the panel a little bit. I'll introduce myself. I'll say something about the background of the resolution. And then we will have 10 minutes of comments from Dr. Amnéus and Professor Noll. And then I will open the floor for comments and discussions. And as some of you have already noted, there's a camera in the corner. We're going to film and make public the interventions in the beginning. When we open the floor, this is not part of what we will make public on the internet. So feel free to have comments and questions without having to consider if this will go public and live elsewhere. Good for you. You prefer. No. So, my name is Matilda Arvidsson. I'm the chair of today's panel. I'm a doctoral student here at the Faculty of Law in International Law and Legal History. And I have invited to comment on the Security Council resolution Dr. Amnéus. She's a senior researcher at the David Wallenberg Institute just across the street. She has been with the Institute since 2009, right? And she has been writing and is researching on, among other things, the responsibility to protect and humanitarian intervention. So this definitely falls within her competence as well. Professor Gregor Noll has been with us as a professor of international law for several years now. He's been researching issues of immigration law, human rights law, theory of international law, and international humanitarian law, just to mention a few fields of his expertise. So, something about the resolution. The situation in Libya must be understood against the background of the events the past few months in the Middle East and Africa, of uprisings, and also as a result of them clashes between governments and popular uprisings, and in the case of Libya, violent such clashes against between the government forces and rebel forces. When the resolution came on last Thursday, late at night, 10 of the Security Council members were in favor and 5 abstained. Those 5 were Brazil, China, Germany, India, and Russia. That's good for us to know as a background story of who supported this resolution. The major points of the resolution, which has been debated and discussed in media so far, is the demand of a ceasefire, the authorization to protect civilians and civilian population under threat of attack, the establishment of a no-fly zone, and the strengthening of the weapon embargo. And of course, this is all acting under Chapter 7 of the UN Charter. There's also an authorization for member states to take all necessary measures and means in order to enforce the provisions of the resolution. This is sort of a general introduction and background to the resolution as such. So, without further comments, I will leave the floor to Dr. Amnéus.
Thank you very much, and thank you very much for taking this initiative to have a discussion and meeting on the current situation in Libya, which is a very important happening among other uprisings in the Middle East and Africa region. So, because of the time limit, I will focus my analysis on 2 areas. I will speak a little bit about the historic precedence of this resolution, and then on the specific mandate on the protection of civilians under the resolution. So as you may already know and have heard, this is a historic resolution. And it's historic for various reasons. It brings together several different security frameworks for the protection of civilians that until now have been treated separately by the international community. The main focus of this operation is the protection of civilians, which distinguishes this case from, example, the intervention in Iraq in 2003 and in Afghanistan 2001. The resolution can be seen as a Kinder egg. It's 3 in 1. And it is an unprecedented manner in containing 3 independent frameworks, or concepts if you like, for the protection of civilians. The resolution authorizes, in the first place, a humanitarian intervention. That means a military intervention with predominant humanitarian motives. Secondly, it is an implementation of the principle of responsibility to protect, R2P, by military enforcement measures. This principle was endorsed by the UN member states in New York at the UN Reform Summit in 2005, and establishes responsibility to protect populations from mass atrocity crimes for all states. Now, the responsibility to protect transfers to the international community when a state manifestly fails to protect against war crimes, crimes against humanity, and genocide. Thirdly, or the third egg in this Kinder egg, is that the authorization includes a civilian protection mandate. And until now, this has only been seen or used in peacekeeping operations, that is, consent-based military operations. These so-called POC, protection of civilian mandates, have been deployed or developed by the Security Council since 1999 in express mandates when authorizing peacekeeping operations to protect civilians. So, what can we say more about this Kinder egg? This is not the first time that the Security Council has authorized humanitarian interventions. We saw several of them in the 1990s with the cases of Somalia, Bosnia, and Rwanda, for example. In all of these situations, the humanitarian crises were determined to constitute a threat to peace under the UN Charter. And this is neither the first time the principle of R2P or the POC framework has been developed. These concepts have grown independently after the NATO bombing campaign in Kosovo in 1999. The military force mandates of these operations did not, however, have any express peace protection of civilian mandates. And I'm talking about the Security Council humanitarian interventions in Somalia, Rwanda, and Bosnia. There were no direct express protection of civilian mandates in those Security Council authorizations. Nevertheless, there was an indirect protection of civilians through the authorization to protect and assist humanitarian relief delivery, UN peacekeeping personnel, protection of safe areas, and providing safe passages for civilians. And in these cases, including the case of Kosovo, the objective has also been to defeat the perpetrators of mass atrocity crimes. Now, in the Libyan resolution, the authorization to use all necessary means under Chapter 7 is combined with this express mandate to protect civilians. And this is the first Security Council resolution of this kind. Now, my second comment to this Kinder egg evolution is that this is neither a first time that we see the reference in the Security Council resolution to the principle of responsibility to protect. But it is the first time that it's made in connection to a Chapter 7 military enforcement decision. The first time the Security Council resolution referred to the responsibility to protect was in 2006, 1 year after its endorsement in New York, in a thematic resolution on the protection of civilians. It has after this been deployed or referred to in several resolutions with regard to the situation in Darfur. And now recently in the resolution 1970 on the non-military sanctions imposed on Libya, but also they refer to the International Criminal Court. Thus, it's the first time that we see an application of the principle of responsibility to protect linked to the authorization of humanitarian intervention. And this should be viewed as a strong confirmation and text of the principle. It can be argued that R2P, by this resolution 1373, has matured as a norm in international relations, now acknowledging the legal right of the Security Council to authorize humanitarian intervention to protect civilians and halt mass atrocity crimes. A third comment to the kinder egg of Resolution 1973 is that it's neither the first time we see an explicit civilian protection mandate. As mentioned, it has been developed as a practice when authorizing peacekeeping operations since 1999, with the first case in Sierra Leone when giving the UNAMCIL, the United Nations mission in Sierra Leone, a protection civilian mandate. And it has been followed up in more than 15 operations in cases like DRC, Liberia, Cote d'Ivoire, Burundi, Haiti, Sudan, etc. These protection of civilian mandates have varied in formulation and scope, but many of them has followed the trend of including the formulation protection of civilians against imminent threat of physical violence. The mandate is usually limited with the following phrases: within capabilities and areas of deployment, and with respect to the responsibility of the host state. Now, comparing this standard of POC mandates of peacekeeping operations with the Libyan resolution, we can conclude that the Libyan mandate is very imprecise, wide and open-ended, which has contributed to much of the criticism on its implementation. So to conclude, to see all of these three security frameworks for the protection of civilians in one Security Council resolution is historic and unprecedented. And it was indeed a very surprising achievement for many of us that the Security Council actually managed to marry the controversial principle of responsibility to protect with a humanitarian intervention strategy and the protection of civilian framework, previously only employed for peacekeeping operations. So, going over to my second comments with regard to the mandate of the protection of civilians under this resolution. Taking a closer look at how it's actually formulated under paragraph 4, it says, authorizes member states acting nationally or through regional organizations or arrangements to take all necessary measures to protect civilians and civilian populated areas under threat of attack in Libya, including Benghazi, while excluding a foreign occupation force of any form on any part of Libyan territory. So there are three important phrases that we need to highlight in this authorization of the use of force or unnecessary means in regard to the protection of civilians. Firstly, it authorizes to take all necessary measures, meaning or indicating that this also includes the use of military force. But it has one important limitation, and that is it has to be short of military occupation. Now, from when or during negotiating this resolution, the authorization of a no-fly zone was considered to be insufficient for many states. But having this second authorization to use all necessary means with regard to protection of civilians, the resolution opens up also to ground troops for protection of civilians, which the no-fly zone did not. Now, the US and other states have indicated that they exclude such measures, but it cannot be ruled out as it is legally accepted under this authorization. The second phrase that I want to highlight is that it focuses on the protection of civilians, but also civilian populated areas under threat of attack in Libya. So the mandate is limited by requiring that the use of all necessary measures are undertaken with the objective of protection of civilians and civilian populations under threat of attack. And this will and may limit some of attacks or use of military force in other parts of the territory where there is no existence of such threats of attack. Another limitation is the lack of an explicit right to undertake a regime change in Libya, and it's controversial whether Gaddafi is a legitimate military target. Some argue that removing him from power is the only way to remove the threat to civilians, while others state that there is no right under international law or under this mandate to do so. The third and last phrase here concerns the exclusion of foreign occupation force when using all necessary measures. And this formulation indicates that any ground troops or military presence in Libya may not place Libyan territory under its authority or exercise authority on the Libyan territory, but must keep to this limited mandate of protecting civilians and civilian populated areas. Now, it may be very difficult to assess when such a line is crossed by the presence of, for example, future ground troops, and I think Gregor will comment more on this issue, so I thank you for your attention.
Now I leave it over to Gregor.
Thank you very much. Thanks, Matilda, for inviting me. Thank you, Diana, for such an excellent introduction to this important topic. And I should emphasize that, in a sense, well, I would share, if you vow to be a newcomer to this topic, I certainly am. As the Libyan crisis evolved, I followed it on TV screens and on the net as everyone else, but I did not have access to some kind of inside information or my capacity of an international lawyer. So if that is your hope, I'm sorry that I have to disappoint you. Now, I want to talk about particular two issues here, and I'll try to be political as well as legal. The first is civilian casualties as a causa belli, as a cause for military intervention, because it seems to me that we need to highlight that a bit more, and I'll try to do so by conjuring up two scenarios, one which is about a ceasefire, and the second is about kind of an ousting of Colonel Gaddafi and his government. And I'll try to look at the consequences of either for the question of whether the objectives of Security Council Resolution 7033 can be achieved. In doing so, I'll hope to be able to say a few words about the issue of occupation, the limits of the concept of occupation, which Diana has already alerted us to. And I'll essentially draw on the same language that you have already quoted, so this is very convenient. And I should also make a disclaimer that there's much more to be discussed here. We could look into a much broader temporal framework, which would involve the issues of migration and refugee law, which would involve issues of democracy under international law. We'll see whether you'll provoke a discussion on that. Now, few would dispute that it is a good thing to prevent civilians from being harmed and killed in conflict. That's probably a very uncontroversial statement. And the language of the resolution of Resolution 1973 is clear. The Security Council expresses in the preambular paragraphs grave concern at the heavy civilian casualties, and expresses as well that the Council's determination is to ensure the protection of civilians and civilian populated areas. So that's highlighted not only in Operative Article 4, already quoted by Diana, but it's also highlighted in the preamble. Now, will the remedy be effective in terms of saving civilian lives? Will the remedy of imposing a no-fly zone and giving the possibility of using military means be effective in terms of saving civilian lives? In order to answer that question, And you see it's not a priori a legal one. I'll make it into a legal one in a minute. To answer this moral question, I look at two scenarios. One is that the coalition indeed enforces a ceasefire, basically makes all combat operation, regardless which side is behind them, makes them stop. And protection of civilians would then be taken to mean no hostilities on either side, government, rebels. This would make the resolution, I'd claim, effectively into a partition resolution. And I quote Operative Article 1 of the Security Council, and I quote, demands the immediate establishment of a ceasefire and a complete end to violence and all attacks against and abuses of civilians. Ceasefire is what I focus on here. It's the first demand raised in the operative articles. If fire is to cease on both sides, this means that Libya is at least temporarily partitioned into a government-controlled and a rebel-controlled territory. This will be very effective in saving civilian lives, and that of combatants too, obviously. But this is obviously not something one would find to be coherent with the second-to-last preambulary paragraph of the same resolution, where the Security Council reaffirms, and I quote, its strong commitment to the sovereignty, independence, territorial integrity, and national unity of the Libyan Arab Jamhuriyyah, end of quote. So, yes, this would be a way forward, but it comes at a price. Second scenario is regime change, already touched upon by Diana. The protection of civilians would here be taken to mean the removal of the Libyan government, including its leader, Colonel Gaddafi, because that would be deemed necessary to remove the threat of attack, which is related to in Operative Article 4. Won't quote it again. Just noting that a look at the language here, namely the words to protect civilians and civilian populated areas under threat of attack in the Libyan Arab Jamhuriyyah, would mean effectively that the coalition intervening would pacify all rebel-held cities and settlements. That would be the consequence of the language relating to civilian populated areas. So it would be a kind of a stalemate imposed. And mind you, there's a weapons embargo in place, although the rumors that Egypt is considering to aid the rebels with weapon shipments, that would be problematic, to say the least, under the resolution. So it is here where the moral issue imposes itself on us. As things look now, a military campaign to oust Gaddafi will neither be short nor surgical. No two interventions are alike, and I should not make comparisons, but on the other hand, historians and international lawyers, all they do is make comparisons with a rather limited set of proceedings. Let's just look at the first 2 years of Operation Enduring Freedom, certainly carried out for a very different purpose in Afghanistan. From 2001 to 2003, it is estimated to have caused between 6,300 and 23,600 direct and indirect deaths of Afghan civilians. That is according to a study by Professor Mark Harold of the University of New Hampshire. There are alternative numbers here too. Of course, this is far from being an exact science. I'm using these numbers plentifully. Now, if something remotely comparable to Afghanistan in 2001 to 2003 would come of Operation Odyssey Dawn, it is obvious that the protection of civilians would be bought by the sacrifice of civilians. And here comes my main point. We should be wary of a discourse that is designating certain civilian deaths as necessary in the name of progress, whereas others are the product of pure evil. We should ask with whom judgment over the necessity of death in the name of progress ultimately rests. That's a moral issue, but it's also a legal issue. Now, let me deliver a few more points which are bringing us into the area of international human rights law, international humanitarian law, and I think then Matilda was talking. A regime change scenario can only be realized at the price of a quite considerable mission creep under Article 4 of the resolution. Now, I think that if a numerical analysis would suggest that civilians are put at risk at a level comparable to that without intervention, I would think that the coalition action contributing to it would be rendered illegal under the language of Article 4. So now is the time to think of what this intervention will amount to in the end, and to think of the limits of legality of action under the wording of operative Article 4. You can't just send further sorties, you can't just send further combat missions into the area without having a clear idea of what that means in the long term. The US actually has made up its mind. It's made quite clear in the past days by its press statements that it will not be contributing to a medium or long-term military engagement in the area, possibly by jamming or by signal intelligence or that kind of stuff. But it will not be contributing airplanes and, well, let's say more decisive military resources. So there's a stand being taken. Did we take such a stand in the Swedish debate, for example? I'm not sure. Now, in order to take a position on this issue, it's absolutely necessary that intelligence be shared with the public on the number and circumstances of civilian casualties caused by military operations of the Gaddafi regime in the past month. Looking at the language of heavy casualties, I quote that from the preamble of the resolution, and the referral of the matter to the International Criminal Court, I think that the Security Council members perforce no more than the general public. If you perform a search on the net for civilian casualties in Libya, you'll find a lot of discussion on the possible civilian casualties being caused by coalition forces, which is really not very helpful for us to assess the limits of Article 4. So what we need to know is what exactly are the numbers of civilian casualties? Exactly is perhaps a misnomer. What are the numbers, what are the ideas of civilian casualties that Security Council members had, at least those Security Council members that were supportive of the resolution? I have no doubt that the direct attacks against civilians, for example, the sniping at demonstrators or bypassing civilians reported by media, qualify as a serious violation of IHL, which opens the door to their qualification as war crimes under the ICC statute, referring to Article 8.2c of the statute of the International Criminal Court. This possibility has been seen and used by the drafters of the resolution, of Resolution 1970 in Article 4, when referring the situation in the Libyan Arab Jamhuriyah to the ICC prosecutor. It appears, however, that neither the threat of prosecution at the ICC nor the intervention itself has put an end to sniping at civilians. That said, we must also underscore that it is legal under international humanitarian law for government forces to attack such civilians that have taken up arms against them in an insurrection. So when making this bizarre calculus of persons killed and harmed by the Libyan government's military operation, or quasi-military operations, one should say, policing operations, we should try to think in the way an international lawyer, an international humanitarian lawyer would think. And that means to ask himself or herself, at what stage do we have a situation of a non-international armed conflict on the territory of Libya, and at what stage are the casualties affecting combatants rather than civilians, and at what stage or in which situations are civilian casualties not a violation of international humanitarian law due to the fact that they were taking part in the course of an attack against a military objective or other combatants, and they were within the confines of proportionality. I won't go deep into that. What we have here is Common Article 3. It's not very much. IHL standards are pretty thin when it comes to non-international armed conflicts. That notwithstanding, we have good possibilities in international criminal law to look at violations and actually to prosecute such violations due to the possibility of a referral to the ICC, which has been used. Now, what do I want to say by making an issue of the body count. The risk I'm seeing is that the case for intervention is made on the basis of civilian casualties, which itself is based on a misconception that every person harmed in Libya, apart from Libyan armed force members, are to be counted as unlawful civilian casualties. In order to take a stand on this, we need more transparency by those governments whose intelligence have led the Security Council to opt for the text of Resolution 1973. And if an assessment by the ICC would show that the scale of civilian casualties was much more limited than generally assumed these days, these weeks, we'd be faced with a situation similar to the discussion on weapons of mass destruction in conjunction with the Iraq invasion in 2003. And that, I think, would be in nobody's interest. So it's curious here that the resolution refers to the widespread and systematic attacks against the civilian population as crimes against humanity, while it says nothing about the possibility that they are war crimes. And I think it's extremely important that the war crime issue is put back on the table.
Thank you. Thank you so much, both Diana and Gregor, for sharing your insightful analysis and giving comments on this resolution.